Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this case, we are going to discuss a Supreme Court case law. The topic is, can a Muslim divorced woman go for filing a petition for maintenance under section 125 Cr.P.C. or not? There is a question. You all know the answer. The answer is yes, because section 125 Cr.P.C. is a secular provision. It applies to anybody, maybe Hindu, Muslim, Sikh or anything, anybody. So once again, such case law has come. Better to know the case laws, because we are discussing right from Shabano, Saira Bano, triple talaq case. Shaira Bano or triple talaq case. So another case has come. So let us know the case law. Muhammad Abdul Samad. Muhammad Abdul Samad versus State of Telangana. In criminal appeal number 2842 by 2024, decided on 10th July 2024 by two judges bench, Madam B.V.Nagaratna and Augustine George Massi. Right. Here the interpretation is also given. It is harmonious construction or purposive interpretation. Another thing is there, it is non-obstantive clause. I explained you non-obstantive clause in case of IT Act. Likewise, you have to remember that 125 Cr.P.C. is a secular provision and it can be used for anybody. Right? Why this trouble has come is because Muslim women, Muslim divorced women, their protection of rights, 1986 Act is also there. Let us discuss some brief facts and then go to the proper legal points. The marriage of Muhammad Abdul Samad with the victim was solemnized on 15/11/2012. You know, in Muslim law it's a contract. Of course, differences cropped up between them. The woman left the accused on 9/4/2016, appellant. She left the husband on 9/4/2016 and actually she is from Hyderabad city. She instituted a criminal complaint against him. So, you know, quite natural, 498A. Crime number 578 by 2017. She filed a case under section 498A and also 406. 498 is harassment. 406 is breach of trust. That is, they might have taken away her gold or other ornaments and did not return back. That is the breach of trust. Right? And coming to know the case filed against him, he was fighting the case in the criminal court. At the same time, he has applied for the so-called triple talaq through Kuzarat or through Muslim procedure. Right? So he has moved for divorce and pronounced triple talaq. And on 25/9/2017, he was granted ex parte divorce by that Kuzat or something, Kuzat. At the time, he wanted to send 15,000 as Iddat period amount, but she refused to take the same. And she moved the court under section 125 Cr.P.C. for maintenance because she is not able to sustain herself. Under the lower family court, granted 20,000 per month. Then he appealed to the High Court. High Court has reduced it to 10,000. Not satisfied with it, he has come to the Supreme Court. Now the fundamental point he raised is, since there is another law, that is Muslim divorced woman within bracket Protection of Rights Act, Protection of Rights in Divorce Act 1986. When there is a separate act is there, 125 Cr.P.C. will not apply. Now the non-obstetric class. Section 3 and 4 of the Muslim Women Divorce Act clearly says this act is not in derogation with the law of the land. It is in addition. That means it is supporting, that's all. So 125 Cr.P.C is not going with the introduction of this act, non-obstetric class. Second, harmonious construction. There are two provisions. Number one, Muslim Divorced Women Protection of Rights Act. Second is 125 Cr.P.C, maintenance under Code of Civil Procedure. These two acts are there to protect the divorced woman who is not able to sustain herself. Right? So she can use any of them. She can use both of them. Both of them should be interpreted harmoniously. Right? And the purpose of the special law is the purposive interpretation. Normally, which is beneficial to her should be interpreted. Harmonious construction. Section 125 cannot be excluded to a Muslim woman irrespective of the law or whether she is divorced or not. So this is purposive interpretation. So Honorable Supreme Court of India mentioned the very famous case law Shabano. Muhammad Ahmad Khan versus Shabano Begum, 1985. So here the Supreme Court of India just touched the topics. Right to social justice. So right to maintenance is social justice because she is not able to maintain herself. Second, wife, normally Muslim wife, she is not able to maintain herself. Then financial security and also security of residence. She has to stay somewhere, is it not? So financial security and security of residence, they have to be protected definitely, and they have to be enhanced to the Muslim woman. So therefore, she can apply under section 125 Cr.P.C also. Friends, you know, presently, I think in BNSS it is section 144. Anyway, good decision. It is one of the added section. Already, previously, we have told you a number of cases. So you can cite this case law also if necessary. For that purpose only, I made this video. Please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.